Alright, we're going to go on with our programming here. We just got a little off the track there just a little bit, just to kind of let you give you an idea where we're coming from. We take a pretty serious attack on the Constitution, and we want to get into some other issues. We want to get into things like money. And one of the best tapes you can get is from a gentleman, we call him Ernie. He basically is known throughout the movement around here. He delivers all the tapes and the what have you. And he has a tape called Wake Up America. And basically it starts telling you how money works and why it works and what they're doing with our money. And when you're done, you really understand what's going on. But we want to share some things with you about the money. And we got a good story to tell you too. But basically, we want to share with you right now in Michigan, the Michigan Compiled Laws programming. Can you see over there? We want to share with you up and to the left. Alright, back. Okay. Alright, we're cool. We're going with it. Alright. 21.153 Michigan Compiled Laws Act. Obligations due state or municipality and date operative when paid by check or legal tender. Whenever any check or bank draft shall be tendered for the payment of any debt, taxes, or other obligation due the state or to any municipality therein, such check draft shall operate as a payment made on the date the check or draft was received and accepted by the receiving officer. If it shall be paid on the presentation without deduction for exchange or cost of collection. All agencies of the state of Michigan shall request that checks tendered in payment of an obligation due the state shall be made payable to the state of Michigan. No receiving officer shall be required to receive in payment of any debt, taxes, or other obligation collectible or receivable by him any tender other than gold or silver coin of the United States, the United States Treasury notes, which you can't get today, gold certificates which you can't get today, silver certificates which you can't get today, or other Federal Reserve bank notes. And there's no bank notes in circulation. There's Federal Reserve notes, but there's no Federal Reserve bank notes. Now the reality is, by this fact, you are specifically precluded from tendering lawfully without being a party to a felony, that of debasement of the coin of the realm against the 1792 Coinage Act, the Sherman Coinage Act. So Roger Sherman wrote a book about this, and it tells you all about coinage and the debasement of the coin of the realm. And that's why he is affiliated with the 1792 Coinage Act. Now the reality to this is, what has been going on over a period of time is they've been playing games with the money. As we can see right here, we have right here a silver certificate. This certifies that there is on deposit in the Treasury of the United States $1, right, of silver, alright? $1 in silver payable to the bearer on demand. Now, we had a little time we got together. We had some of these notes. We had some gold certificate notes. Also, we got one here that says, United States note, the United States of America. Now, notice the difference here, folks. This one just says this note is legal tender for all debts public and private, but we know that that's a lie because Article 1, Section 10 of the Constitution says nothing but gold and silver coin shall be made a tender in payment of debt. Now this is going to bring up a real interesting case that we got here. Now, we went down to the Federal Reserve Bank and we took $500 worth of, these are silver certificates here, but we took gold certificates, $20 gold pieces. We had $500 worth, and we went in the Federal Reserve Bank, and I walked up to the window and I said, "I'm the bearer on demand and lawful money of account of the United States government, sir." I said, "I want my gold." I handed her the notes. She looked at me and she says, "Sir, we don't have any gold." I said, "Are you trying to tell me this bank is overextended?" Everybody looks. "You can't come in here and do that, sir. You're going to get a run on the bank." I said, I'm asking you for my gold. I'm the bearer. I am herein before you demanding. It says pay to the bearer on demand and lawful money of the account of the United States government and $20 gold. I got $500 worth of these, and I'll take $20 gold pieces. We don't have any gold. "Are you trying to tell me this bank is overextended?" So they called the SWAT team. This lieutenant comes running up, and all these guys got rifles, and they're all at port arms. And the lieutenant walks up to me and says, all right, what the hell is going on here? So I explained to him. I said, sir, I am the bearer on demand and lawful money of account of the United States government. I'm here and before this bank. This is a lawful bank of the government. And I'm asking them to pay me, the bearer, on demand, my $20 in gold for every one of these $20 gold demand deposit notes that I have. And I have up to $500 worth. And I just asked her for the gold. She told me she doesn't have any gold. I tried to tell her, you told me this bank's overextended. She told me, you can't come in here and do that. And the next thing you know, you show up. The lieutenant looked at him. He said, why don't you give the guy his gold? Come on, guys, we're out of here. So they left. They couldn't give me my gold because they ain't got any gold. But there is a contract on here that says pay to the bearer on demand. Now in this one it's $1 of silver. In theory, the contract is there and you could, in theory, go collect it. But upon trying to collect it, there is no gold. There is no silver. They don't have any. Now over a long period of time in barter, we have slowly been pushed into a position of impossibility to perform. Now, can the hat check be the hat? Can you walk in and check your hat and get a hat check? And then when you come back to get your hat back, they hand you another hat check? Can you wear the hat check? Obviously not. So obviously the note is not the dollar. All it is the promise to pay $1. Does everybody understand that? And what has happened over a long period of time in custom and uses is the people have been hoodwinked into thinking that they have money, dollars. There are no dollars. Dollar is a unit of measurement. Which brings up a very famous case, the case of Montgomery Wards versus Eugene Glacier. For those of you who want to order the case, we'll be happy to give you the court case numbers. Let me take this off so it doesn't reflect too much. This is a very famous case, okay? The docket number is 82-002087. This is before the Honorable District Court of 52nd 3rd District Court. The judge of the record was the Honorable James P. Sheehy, okay? Now, I'll give you a little synopsis of this case. What happened in this case? Did everybody get the court number first, though? 82-002087. All right, now, what happened in this case, to make a long story short, this gentleman's wife got a little mad at him and decided to take his credit card and go out and charge to Montgomery Wards from the front door to the back door, and he ran up quite a large sum of debt. The matter got, of course, Montgomery Wards wasn't going to take it back. You bought it, it's yours, you got it. Now, they went to court and came up before the famous Judge James P. Sheehy of 52nd 3rd District Court, who, by the way, is a very excellent judge, very knowledgeable, very a decent man, a kindly man. He's pretty serious business, though. If you're screwing around, he's going to hammer you, but most of the time he's quite congenial and kind of a lot of fun, too. But it came up before his court, and up jumped the devil in the deep blue sea, and they're starting to argue, and the judge is saying, well, let me ask you a question. He said, did you get a credit card? He said, yeah. So you signed for the credit card? He said, yeah. He said, you give the credit card to your wife? He said, yeah. He said, here's the bill. You pay. He says, okay, Judge, now let me explain something to you. You told me that the judgment is for this amount. Is that right? And I'm asking you, and you told me it's this many dollars, and I'm asking you for a determination of the dollars. What dollars? He said, sir, you can interpret it any way you want. You can make it frankincense or myrrh. I don't care. I don't care if you don't even pay this judgment. I'll tell you what, don't pay it. There's a lot of documents in the basement, they never pay them. He says, don't pay it. We'll just take judgment against you, and we'll attach it, whatever we need for writs of attachment, and we're going to collect on this debt. He said, sir, you misunderstand my point. Now, you have told me this amount of dollars, and I'm confused here. I need to know something about these dollars. He says, let me clarify it for you. I've entered a judgment against you for the amount due, all right? He said, yes, sir, but if I ask you for a pound of something, you're going to say a pound of what? And if I ask you for a gallon of something, you're going to say a gallon of what? And if I ask you for a foot or a yard of something, you're going to say a foot or a yard of what? Now, you're coming to me and telling me dollars, and I'm asking you dollars of what? Because dollar is a unit of measurement. He said, you can make it anything you want. Tell you what, make it coffee beans. Now, at that instant, the Montgomery Wards attorney came to a half rise, and he went, Your Honor? Your Honor? There was 40 of us plus in the court, and we sat there, and all we could do was go, because we realized instantly what this judge had just did. He had made a determination of the substance of the money of account of the United States government pursuant to coffee beans. With great courage, the Honorable Judge James P. Sheehy had made a determination that the substance of the money of account of the United States government was coffee beans. That's what we told the Wall Street Journal and all the newspapers and television stations that would listen. He was most upset about that. Instantly, the judge looked across the room. We're all sitting with our jaw on the ground. And he leaned back in his chair, flipped his pencil in the air, and he said, "Ah, S with a hit," on the record. He realized that a landmark Michigan court decision had occurred. He realized that Montgomery Wards wasn't going to say nothing, because they won. They ain't going to appeal. They won. What are they going to appeal? You won. You won. You won. You won. There's nothing to appeal. We weren't going to appeal because we won too. We got the judge to make a determination that the substance of the money of account of the United States government was coffee beans. You can see in the back of this book here, Mr. Glacier took the judgment right here, and this was for $1,098.97. He did it in 100 bean bags certified, 1 bean to the dollar, and 97 100ths. We cut the tip of the bean off, painted a white line on it. He sent it to Montgomery Wards. We got it on there? Mm-hmm. Please find enclosed in this package 1,148 coffee beans, which is payment in full, pursuant to Judge of the 52nd District Court, October 8, 1982, before His Honorable Judge James P. Sheehy. I thank you, sir, for your time and trouble concerning this matter. Most graciously, yours truly, Eugene Glacier. And it's certified mail sent to him. They never said nothing, nor would they, nor could they. He honored the stipulation of the judge. Okay? Now, to this date, this gentleman comes to court with a big red bag, marble bag, full of coffee beans that he's got stenciled on the side, Gene's Beans. I'll read you the last statement. This is kind of hilarious. It's pretty good. He's asking for a determination of the substance of the money of account. I'll read you about the last 3 pages. He goes, all right. Therefore, really out of his own testimony, it seems to me that judgment really is unavoidable in that amount. Thank you, Your Honor, the court. Anything else, sir? You have the right to a closing argument, Mr. Glacier. Only that I don't think I received a fair and equitable trial here today, the court. This is a closing argument regarding this trial, okay? As to the subject matter, Mr. Glacier, subject matter, I have nothing to add to the subject matter here, the court. The court makes the following finding of facts, that the court finds that pursuant to Plaintiff's Exhibit Number 1, that Mr. Glacier, Eugene Glacier, entered into a contract with Montgomery Wards and the company which it is a monthly account. 2, pursuant to Plaintiff's Exhibit Number 2, that the account was used by probably 99% of the time of the purchases by his wife while they were married. Number 3, that for testimony of Mr. Davison's unrebutted testimony, Mr. Davison, the balance owing on the account is $1,098.97. And the court also finds that Mr. Grossman's excuse me from Mr. Glacier's testimony that he just recently got divorced, approximately August 24, 1981. And in that divorce proceeding, he accepted the liability on this account as between he and his wife. Based upon the information, the court makes a conclusion of law that Mr. Eugene Glacier, defendant, this matter owes Montgomery Ward $1,988.97. Court finds a judgment in favor of plaintiff in the amount of plus costs. Mr. Glacier, you have a right to appeal this, and that appeal, I think, is in 15 or 20 days, Mr. Grossman. Mr. Grossman, 20, Your Honor, 21, actually, out of county 23. I think it's 20 all over now, Your Honor, the court. I think it is. It used to be 15 on some cases and 20 on others, and I could never keep it straight, but I think it's 20. You have a right to appeal in 20 days. If you appeal, let me explain to you how you do that. You have the file with the court with the circuit claim of appeal. Are those the ones that are marked by the way those exhibits? Mr. Grossman, oh yes, sir, Your Honor, that's right. The court. We better keep those. You can give him a copy of the other ones. By the way, you can file a claim of appeal with the circuit court in this court. You also make a request to the court stenographer for a copy of the record. A copy of the record must file within a certain amount of time. That you can tell you must file, as I say, a claim of appeal, and then you have a certain number of days after that to file your appeal. Okay, claim of appeal is nothing more than a little form. I hereby claim appeal. Okay, so but the court clerks can give you more information. But if you don't file an appeal within 20 days, you've lost your right for an appeal. Any other questions before the court recesses? I'd still like to have a motion for a more definite statement. Dollars of what? Do I owe the court dollars of what? The court. The court has made it. Now this is after he had already told him dollars of what before, and the judge told him frankincense and myrrh, and then he kept hammering away at this dollars of what, and then the court lost its cool. The court has made a judgment of $1,098.97, and however you interpret that, sir, if you want that in coffee beans, that's okay with me. Really? Okay, thank you much. And at that point, we all went, ah. And he went, oh, S with a hit. He realized he threw his pencil up in the air. Now, this is a magnificent case and an example. And to this day, this gentleman still pays court judgments with coffee beans. And it's a viable case. You can use the case as a reference. It's a landmark Michigan court decision. We use it thoroughly. Okay? Now, to make a long story short, Article 1, Section 10 of the Constitution is clear and specific. It says nothing but gold and silver coin shall be made a tender in payment of debt.